Welcome to If You Don't Plan, You Are Stupid.
Welcome to If You Don't Plan, You Are Stupid, with estate planning attorney Andrew Rosenberg. We're here to cut through the confusion, crush the myths, and show why planning your future is the smartest move you'll ever make. Whether you're 25 or 85, if you have a family, a house, or just a life you care about, it's time to get serious. Let's make sure you protect what matters most before it's too late. I'm your host, John Clements, and today's episode is Wills versus Trust. What's the difference and which one do you need? So to start with, Andy, welcome back to the show.
Hey, John, how you doing today?
I'm doing great, man. I'm excited you're here.
I'm good too, man. It's Friday. It's almost the weekend. I can't wait.
Exactly. So let's start simple, though. We got to talk through some legal stuff before we can get to the weekend. So let's just start with the basics. What's the difference between a will and a trust?
Okay, we're going to get into it. Here we go. Huge difference. Huge difference. So here's number one. This is basically what I want people to know. A will means probate, okay? That's as simple as I can say it. A will equals probate. A will guarantees probate, and that's not something we want to deal with. So most people think that if they have that will, which we talked about in the prior episode, John, that if they have a will and they have less than a certain amount of assets, they're fine, and it's just going to go how it's supposed to go, like the movies, and that's completely bullshit, okay? That's not how it works. What happens is we're going to have to go through the probate process, and I'll talk about that in a minute. The purpose of the trust, the main purpose of the trust, and when we're talking about trust, there's all different types of trust, John. There's irrevocable trust, there's revocable trust, and there's all different types within there. We're going to mainly talk about, which is what everyone wants to talk about, the revocable trust, which is a trust that you can make changes to, amendments, etc. What's the main purpose of the revocable trust is that it avoids probate. It doesn't go through the court system, and it goes smoothly to wherever you want it to go. So I'm going to, if it's okay, I'll elaborate further if you want me to about how that all works. You tell me if that's where you want me to go.
Yeah, well, let's look at it this way. So you've got the will, you've got the trust, and it's basically whether it goes through probate or not is one of the main differentiators. Are there times when it's enough to have a will, or is it always better to go with the trust? Or like how does that decision work?
That's an awesome question. So here's what you need to know. To do an estate plan, which is what my firm does. When I'm sitting down with a client, I have to analyze their whole situation as far as what their assets are, what their liabilities are, how the titling of their assets are, etc. And that's really going to help me determine whether a will is going to be appropriate for them, John, and that's going to be enough, or if we need to do trust work. So a lot of times when I do workshops, I do a lot of live workshops. Most people, when they sit down and meet with me, almost 100% of the people that meet with me, they all say, Andy, we have to do trust work. And it's my job, at least I feel it's my job, to sit down with them and say, hey, hold on a second. Maybe there's ways that we can plan where I could do it with a will and other documents, and it's going to be less expensive for you. So the answer to your question is, yeah, there are times where a will is more than enough. Now, there's a bunch of documents that you need to have no matter what, not just the will. But the scenario is, I tell people, listen, a will can be enough in a lot of situations, at least in Florida, okay? Because Florida, we'll talk another episode about what's called ladybird deeds, but I do a lot of ladybird deeds for the real estate because we're able to name beneficiaries on the real estate to avoid probate court. And then we have assets that are in joint name or that you can name beneficiaries for, like IRAs and 401ks. So if you got someone that has like a real estate, like they own a condo or a home, and they have an IRA or a 401k and a couple of bank accounts, and you're able to put beneficiaries on all these accounts, then a will's good enough because it really probably won't even be used because there's beneficiaries there. However, there's lots of times where a will not be enough, and that's when we have to talk about the trust situation. And a lot of times that will kick in when we have accounts or assets that we can't do beneficiaries for, or we have children we got problem children, we got kids that maybe have special needs issues, or maybe we have kids that are not good with their financial affairs and we don't trust them when they get the money, or maybe we want to spread out the money when we do pass away over ages, or over a lifetime we want to hold it in trust for them. So there's a myriad of reasons to do a trust, but it's not always necessary.
I see. And so I do have a follow-up question with that because when you say the word trust, I know in my mind, I think about millionaires, people with a lot more money than I have. And, I mean, there's even like the phrase trust fund baby. Like that's just how we kind of associate trust. So does it matter how much money I have as to whether I need a trust? Like, is that a differentiator or does that even come into play?
I'm going to give you the attorney answer. All right.
Okay.
It depends.
I do hear that a
So,
lot. Yeah.
yeah. So I tell people, listen, I don't necessarily worry about how much money you have as to whether a trust makes sense or not makes sense versus a will. I really, it's a factor. It's definitely a factor. But I also really need to understand your situation and what's going on with you. Meaning, I need to understand how the accounts are titled. Attorneys don't talk about this a lot. I have a whole 15 minutes in my workshop. I just talk about titling of asset and how important it is. So I really need to understand how you have your assets titled, all your accounts, your life insurance, your IRAs, 401ks, investment accounts, real estate, all that stuff. Do you own businesses, not business, LLCs, S corp, all this kind of stuff? We got to find out how things are titled, and then we need to find out obviously how much money's in all this stuff. So your question is, trusts are meant for everyday people. Okay, you don't have to be a millionaire to have a trust. Let me give you an example. So let's say that I meet with a husband and wife, and they have, bank accounts and then IRAs, 401ks, a real estate, and all that stuff. And we could set it all up, John, where everything is set up perfectly, where we can do a trust and we do a ladybird deed, which we'll talk about in another episode. And we have title of assets, and a will is going to be enough. But and we'll avoid probate court. That's my job, to try and avoid the courts. But let's say they have 3 kids and we have some issues with the kids, meaning let's say one of the kids has a lawsuit against them. Okay. They got in a car accident and it's their fault and they're suing them. Or let's say we got a kid that is in the middle of a divorce, or or you don't like the spouse and you think that they're not going to stick together long term. That's a perfect scenario where an everyday couple, we could do estate planning with a will and other documents and not need trust work for less money, where it rolls over now into, well, now we need to talk about trust work. Because in a trust situation, we can protect the beneficiaries, the kids, from a divorce, from a lawsuit, from a bankruptcy, if they are getting the money and it's left in the trust for them when it's time for them to receive the funds. So again, there's a lot of factors that determine whether we need to do a will versus a trust. But a lot of times it depends on you, meaning the client, and what your big concerns are with the family and with the kids, and how do you want things distributed.
Yeah, that's a whole lot more factors than I think I previously considered. So thank you for just bringing that up, because I think, most of us, we don't know because we don't deal with it every day. So what a great resource to just ask, and have you tell us. And I do want to kind of drill into, we keep mentioning probate court, and I want to make sure everyone knows what that is. So could you give us like the real quick Reader's Digest version of what probate court is and how that might factor into your decision of, do I need a will? Do I need a trust?
I tell people we want to avoid probate where we can at all costs. Okay. There's 3 problems with probate. I'm talking about Florida. Okay. Now every state is different. Some states, it's a lot easier to deal with probate. Okay. In Florida, it's a nightmare. Okay. 3 problems with probate in Florida. Number 1, it's expensive. So basically what probate court is, let's go back. Probate court is when someone passes away, John, and they have assets in their name alone. No beneficiary to an account, no anything like that. It's just in their name. So the example we gave in the prior podcast was, I own my house and it's in my name alone and I die. That's going to go through probate court. So any assets you have that when you pass away that are in your name alone is going to go through probate court without a beneficiary form or anything. That's probate. What's the problem with probate? Number 1, it's expensive. How expensive? Let's use my house as an example. Let's just say it's not, but let's just say my house is worth $1 million. In Florida, there's a statute that determines how much a reasonable fee is for an attorney to charge to handle the probate court process. And you want to guess what it is, John? It's a percentage.
I don't know, 10%.
Nope, 3%. Nope. But 3% of $1 million is a lot of money.
That's still a lot.
$30,000 bucks. That's $30,000 going to me as the attorney. So the first problem is that it's expensive. And then in addition to that, you have the executor of the will, or what we call in Florida the personal representative, PR, same thing. They're entitled to 3% as well if they want to take it. They don't have to take it, but it's there. So it could be 6% in fees. That's the first problem. Second problem is it takes time. takes time to go through the process. In Florida, on average, it's 12 to 18 months from start to finish, and it could be a lot longer if there's litigation involved. Unfortunately, it takes a long time. Why? Give you a quick example. When we start a probate process, there's a bunch of opening documents that I have to get signed by the person that's going to be the executor or personal representative. We sign all that paperwork, we send it to the court, and hope that the court says it's in good order. If everything's in good order, then they issue us a case number. Then we send in the will and we send in a death certificate, and then they issue what's called letters of administration, which is the authority that would name you, John, if you're the executor, to handle things. Then we have to publish in a newspaper for 2 weeks in a row and wait 3 months for creditors. So just right there, that's 3 to 5 months right there without even doing anything. That's the initial process. So probate, expensive and time consuming, not to mention there's only a couple of judges in the county that handle it. And if they go on vacation, they get sick days, they have emergency court hearings, it just delays everything. So expensive, time consuming. Third problem with probate is that it's public. And a lot of people don't like to have their things listed in public. I got a quick story for you. 30 years ago, when I started out, I handled a probate. It was a widow, and the widow passed away, and I'm handling the probate. We did what I told you about. We opened up the probate. We published in a newspaper and waited 3 months to see if creditors came out. We had a creditor file against the estate. It was a roofing company, and they said that they are owed 50% deposit on the roof contract that they were supposed to fix the widow's house who passed away, and it was about a $28,000 roof at that time. So they were owed $14,000. Well, I thought it was kind of fishy, and I ended up doing some research with the kids. We found out that the contract from the roofer, they forged it and filed it against the estate. How'd they forge it? They went to the public records, they saw the will, they copied the signature onto their contract and filed. It's changed now. It's harder. Now they don't publish the will, so you can't see the signature of the person that passed away. But that's just a quick example of how easily it could happen. And there's fraud all day long in the court system, not on purpose, but it happens. So again, probate's expensive, time consuming, and it's public record.
You know, you're really not selling me on the probate court, Andy. Makes me not want to do it.
Yeah. Yeah, I'm okay if you want to do it because I get paid 3%.
Yeah, but I appreciate you have the integrity and honesty to say you don't want to do this.
Yeah, you definitely don't, and it's horrible on the entire family that survived.
Oh, I can imagine. So that's part of the, I guess, let's say risks that you might face with a will or without a will, whether if you have to go through the probate court. Are there any other hidden risks that someone who just has a will and maybe not a trust that they could face later on?
Yes. So people are thinking about death, right? Which is where the will and the trust kicks in. But what people don't realize is there's more to estate planning than death. What happens if you become disabled or incapacitated? The will's not going to handle that situation. So there's more to estate planning than just the will or just the trust. There's a lot of other documents, which we will get into in future episodes. But you don't want to be unprepared if, God forbid, you end up getting into a car accident and you're unconscious and you can't handle your financial affairs. Because then we have a whole separate court system called guardianship court. You remember Britney Spears out in California?
Yeah, oh yeah, that whole
The
thing,
singer,
yeah.
you know, the singer,
Mhm.
and then her
Yeah.
father got involved and all that stuff out in California. They call it a conservatorship out there. That's a guardianship. That's when someone is over 18 and they can't handle their financial affairs because they're disabled or incapacitated. And out there, the court determined that she was cuckoo and that she couldn't handle herself. And so that's why they appointed her father. And then we had all this fraud going on. That's a mess. And it's expensive. You have to have courts, attorneys, etc. So we really don't want to go through that system. And a will is not going to protect you from that. And a trust will, by the way, a trust will. But how do you protect yourself from that situation if you just have a will? You have something called a durable power of attorney, which we'll talk about in later episodes. But yes, a will's not be all end all.
Yeah, I think that's the big takeaway for me for these first 2 episodes is just learning that. So we've talked about a lot of stuff. You shared a lot of amazing stories. There's a whole lot of legal information that you have to wade through. So if someone is listening to us and they say, Andy, this sounds great, but I don't know what I need. I don't even know where to start. What would you tell someone? Like, what's the first step they should take in this whole process?
First step they should make is you need to meet with a qualified estate planning attorney. Okay, make sure they got a good reputation, etc. And you need to meet with them for a consultation. And when you do that consultation, make sure you've thought before you sit down with that attorney, he or she, and make sure that you put together a list of your assets and how things are titled so that it's an easier conversation with the attorney. And then they can kind of give you input on different options that you might have to go to as far as an estate plan. And remember, guys, it's not just the will, it's not just a trust. There's more to estate plan than just that. But that's my recommendation, is everybody should meet with an estate attorney to go over their financial stuff. But make sure you meet with a quality person and that you feel comfortable with that person, and then make sure you're organized in that initial meeting.
Yeah, I think that's great advice. Go find an expert who you can trust and just start a plan. Andy, it's been fun, it's been informative, it's been entertaining. It's been just a great experience having you on the show today. Thank you so much.
You got it, John. And remember, if you don't plan, you're stupid.
That's right. And so to our listeners, thank you for joining us on If You Don't Plan, You're Stupid. If today's episode made you think twice about putting it off, good, because that's the point. If you're ready to take action, visit rosenberglawfirm.net to start building your estate plan today. And don't forget to subscribe, leave us a review, and share this episode with someone who needs a reminder that your future is too important to leave to chance. And with that, I hope you have a great day.
Take care, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.